Welcome, folks. You're tuned into the E Pluribus Unum Exchange and Trust Network, your go-to place for understanding complex legal concepts like trust law. Before we dive in, a quick disclaimer. We are not a legal or financial institution and do not provide legal or financial advice. Our goal is to simplify and demystify these concepts for you. However, we always encourage you to conduct your own research and seek professional advice when needed. We will provide our recommendations at the end of the video and in the description. So sit back, relax, and enjoy this informative journey into the world of trust law. And remember, when in doubt, always seek professional advice. Have you ever wondered about the control test in trust law and its immense importance? Well, buckle up, because today we're diving into the fascinating world of trusts and law, unraveling the significance of the control test through a hypothetical case study. Imagine a bustling city, and within it, there's a successful entrepreneur. Let's call him Mr. Smith. Smith has amassed considerable wealth and wants to set up a trust. He decides to establish a grantor trust, retaining control over the trust's operations. But here lies the first pitfall. Did you know nearly 95% of the trusts prosecuted as sham trusts by the IRS are grantor trusts? Why? Because the grantor, like Mr. Smith, holds onto control, making the trust an extension of their persona, their alter ego, offering no protection. The control test for trusts firmly states that the grantor must relinquish control to an adverse party. This means someone unrelated and independent, not family, blood relatives, or significant others. If a grantor, like Mr. Smith, can dismantle a trust, it does not pass the control test and was never an irrevocable trust to begin with. So what should Mr. Smith do? He should pass the baton of control to a trustee, making his trust an express trust. This principle, well settled in courts of equity, emphasizes that control must ultimately rest with the trustees of the trust. When full legal title and control over the trust property are vested absolutely in the trustees, the interest holders cannot be considered partners or agents, and therefore cannot be held liable for the debts of the trust. In our hypothetical scenario, Mr. Smith could discuss with a friend or neighbor to serve as the grantor, while he personally serves as the trustee and assigns his family as beneficiaries. He could also be a beneficiary, provided he's not the sole beneficiary. In the future, Mr. Smith could exchange assets into the trust res as trustee, but he must avoid gifting or granting assets to avoid violating the Fraudulent Conveyances Act. Remember, as the U.S. Supreme Court stated in Burnett v. Smith, ownership means liability. To be free, one should control and not own in contracts. In summary, the control test is essential in trust law, determining the validity of trusts and their protection against scrutiny, particularly by entities like the IRS. To pass this test, a grantor must relinquish control to an adverse party, meaning someone unrelated and independent. Control ultimately lies with the trustees, for a trust to be recognized as an express trust. Understanding this relationship between ownership and liability is crucial in strategically setting up trusts, ensuring they stand firm against legal scrutiny. So, the next time you hear about the control test in trust law, you'll know exactly what it means and why it's so important. The E Pluribus Unum Exchange and Trust Network recommends reading the Weiss's Concise Trustee Handbook, a guide to the administration of an express trust under the common law, functioning under the general law merchant by Carlton Albert Weiss. Thanks for joining us on this journey through the intriguing world of trusts and laws, and until next time, keep questioning, keep learning. Did you know that the irrevocable trust is the trust used most on the E Pluribus Unum Exchange and Trust Network? Yes, that's right. Irrevocable trusts, with their unique benefits and protective features, have become an essential tool for many. But why is it so? What makes an irrevocable trust a popular choice among our network members? Well, we are here to help you delve deeper into this subject. We invite you to contact us to find out why and how irrevocable trusts are used. Our team of experts is ready to guide you through the intricate details of this trust system and help you understand how it can fit into your legal and financial strategies. So don't hesitate. Reach out to us today to learn more about the power of irrevocable trusts. Remember, knowledge is power, and it's never too late to learn something new. We look forward to hearing from you soon.